Thank you very much once again. Just before I introduce Sean Cash, I want to thank Michael Green and his two great assistants, Brett Bowker and Luke Hales, who do a terrific job in organising these events. We trust there are some assistance to you. We like to do it, and we like to have you here on behalf of the list, as I said, of which I'm a very proud member of many years. Speaking of many years, the next speaker is Sean Cash. In May of this year celebrated his 22nd year at the Victorian Bar, and on this list he's known as a fantastic cross-examiner. He's got a CV that Moss Trooper couldn't jump over, but what's not on his CV is really the highlight of his career, and that is being awarded the Legal Personality of the Year at the Celtic Club, and that was the inaugural Legal Personality of the Year, so it goes back for time immemorial. He still holds the title, and I don't know what he does at the Celtic Club. Paul Anthony Michael Scanlon doesn't get to those places. So on behalf of our list and Michael Green, I'd like to introduce to you one of our list members, Sean Cash.
Can you hear me, everyone? Good. When you've achieved so little in the law, you've got to rely on any achievements that, like those sorts of achievements. Look, I just want to say I'm going to be relatively quick. One of our list members has just been made a judge, John Carmody, and I know that a few of us are keen to get to his welcome at 9:15 this morning, and so I do want to, though, at the outset, echo the thanks that Scanners has just conveyed to Michael Green, Luke and Brett. No, none of the clerks are generally working until about 8:30 or thereabouts. Green's list is fantastic in that it's trying to promote the list, in that it represents health practitioners, and Green's list has really put in and regularly puts in. It's appreciated by its members, and in particular myself, and so thank you. And Scanners, thanks for being here. I recognise that normally, of course, at this time of the day you're having your beauty sleep, but it's appreciated that you're here. Well, look, what I've got is this document, which I hope will be of assistance to you. You can take it back to your office and put it in the cabinet, and hopefully, if you've got a disciplinary matter, you can take it out of the cabinet, and there it will be, and will be of assistance to you in future. Don't hesitate to pick up the phone, give myself or anybody on Green's list a ring if you've got any questions about how to proceed. Often practitioners don't do that. They think about perhaps ringing a barrister, but they're a bit hesitant. Don't hesitate, just ring the barristers. We're there to help you. We know in the long term that you might brief us, but we're there to assist you if you want our assistance. If for example, there's a show cause hearing coming up and you're thinking, how am I going to phrase this document on behalf of the client in response, just give us a ring and we'll have a talk about it. And so what I want to do is to start at the first page of this document by recognising that one of the first things that a practitioner or the practitioner will first learn of the investigation when AHPRA advises him of it, the Australian Health Practitioner Regulation Agency. And what will invariably happen almost immediately thereafter, if they're minded to do so, is that the board will invite a submission from the practitioner as to why immediate action in relation to the practitioner should not occur in the form of suspension pending the outcome of the investigation. And so what you have to do at an early stage is turn your mind to how it is that we should be responding to this invitation to address the board at its meeting. You'll be asked to attend if you want to, and make a submission in person, and to provide a submission in writing as well if you want to. And so it's very important to consider, what am I going to put in this document? What you've got to, if the practitioner denies the allegations, then the safest position might simply be to make a denial and not descend into detail in relation to the facts, because if you descend into detail in relation to the facts, you're really committing yourself to a position, and you might not want to commit yourself to the minutiae of the details that you'll ultimately be addressing in the case, because you might then be in effect you're then in cement, aren't you? You can't really change your position later on. So the initial response to APRA, how should the practitioner respond? It's a matter of personal choice. The practitioner might want to, I know that some solicitors prefer not to have the solicitor's letterhead on the response, because it looks as though it's been generated by the solicitor rather than the practitioner, the health practitioner. It's always important to consider that if the matter is ultimately referred to VCAT for a hearing, the response is something that will effectively bind the practitioner. It therefore needs to be a considered document. And so in considering the response, you really need to appreciate as to whether there's been an inquest or a show cause hearing prior to the VCAT hearing. And so you need to be aware of what was said on behalf of the practitioner at the show cause hearing or at the inquest, if the health practitioner has given evidence, before settling the witness statement, if she's made one. The response should either be detailed or concise, depending upon the circumstances. Now, if the allegations are very serious and or convoluted, and you've got a confidence that the allegations will be referred to a hearing, you might prefer to simply deny the allegations without any condescension to detail. You really shouldn't feel afraid to simply respond by providing a simple denial. You mustn't feel the need to, of necessity, provide a detailed response. A letter to this effect, I deny the allegations, can often be enough. The downside of that, of course, though, is that they've got a discretion at that stage as to whether they're going to proceed to refer the matter to VCAT. So it may be that if your response isn't compelling enough, that they might, in their discretion, decide to persist with the referral to VCAT. And so it is that the matter may be referred off to VCAT for a hearing. And what will happen is that the practitioner will be in receipt of a referral letter. And the applicable legislation and the relevant practice notes are set out here, and the date of the alleged conduct will determine the legislation which governs it. This is pretty trite, what I'm referring to at the moment. I'm conscious that we've got very experienced practitioners here and relatively new practitioners, so I won't go into the particular pieces of legislation which might govern a particular conduct, but it's set out there at the base of page 2. On page 3, the two practice notes which have particular application in these types of hearings are set out. I won't... Andrew Smith suggested that, although I noticed he's not here, wanted me to go through this, so because he's not here I won't, but insofar as that practice note number 1's concerned, I don't propose to go through it, it'd bore you, but the fact of the matter is it's only recent. It came into being, into operation on the 31st of March. You really need to just know that it's there. Go and have a look at that when you are preparing for a disciplinary hearing. But of interest is how it is that directions hearings now are going to be by telephone, and of interest as well is, you'll see in the last dot point, unless the tribunal gives leave to do so, no party shall 2, call a witness whose statement has not been provided. Just note that, because I'll be coming back to that in a moment. The question arises, when you're preparing a case, should you get your practitioner, health practitioner, to be providing a statement in advance? So we'll come back to that in a moment. Now, the referral letter, of course, contains the allegations and spells out the determinations that may be made. The allegations will be in relation to the conduct of the health practitioner. Now, there's a myriad range of conduct. It's not only medical mismanagement. In fact, not so many of the cases involve medical mismanagement as they do professional boundary transgressions. In Love, for example, despite its name and what you might think it implies, that was a psychologist I acted for who went into a business with a former patient. In the Chinese Medicine Registration Board in Schultz, he had twins to a former patient. You know, some of the allegations relate to just downright stupidity, for want of a better expression. I mean, Mr. Ho, the optometrist, was involved in upskirting, for want of a better expression. Mr. Sketcher came to me in circumstances where, goodness knows only why, he decided to take the opportunity to photograph the breasts of his sleepwalking intern. The optometrist, Mr. DeSantis, we had an awkward conference in circumstances where his wife was present at the time. She was in the reception area when the 19-year-old patient ran screaming from the consulting room, and thereupon went and asked Mr. DeSantis what on earth had happened, and the optometrist was at a loss to explain why she's run out. Let's just say that he had really sought to test her peripheral vision. And Dr. Young, notoriously somewhat, the runner-up in the Clio Bachelor of the Year, how do I describe what he got up to? But he was providing, he was doing the tests, STD tests for local prostitutes in St Kilda, and let's just say that he came to an oral arrangement with one of the patients in the consulting rooms. The allegations will also relate to conduct outside the practice. Mr. Munzel had the Medical Radiation Practitioners Board prosecute him. He'd indecently assaulted his own daughter, and it's comforting to know that by virtue of my efforts he's back out there practising. He pleaded guilty in the criminal courts, and by virtue of that conduct outside his practice, he found himself before VCAT in disciplinary proceedings. Now, the allegations will generally allege conduct which is said to amount to either unprofessional conduct or professional misconduct. Professional misconduct is regarded as the worst of the two. I'm not going to take the opportunity now to go through what the difference between those categorisations are. I want to go through, because that's, you can find that in the authorities and it's relatively straightforward. But insofar as the determinations are concerned, we know that there are all sorts of determinations, from cautions right through to cancellation of registration. Particulars. The allegations will generally be particularised, and you as the practitioner should know that you need to know that the applicant board doesn't have to prove the allegations exactly. It's not like a criminal court where the elements of the offence have to be proven beyond reasonable doubt. Rather, I suppose the best way to put it is that if it's proven to be more or less that which is being alleged, then that's enough. In Swiker, I sought to draw the tribunal's attention to how the first allegation was particularised by reference to very specific conduct when it was articulated in that allegation that this particular doctor had pushed, grabbed and dragged his patient along the consulting room floor. But the tribunal took the view, look, it doesn't matter if those particular allegations aren't proven, as long as the tribunal was satisfied that there was actual physical abuse proved. The usual orders you'll see are contained in the practice note. I won't go through those. But the parties can, by agreement in writing, seek a compulsory conference. And so let's talk about compulsory conferences. Compulsory conferences are there to identify and clarify the nature of the issues in dispute in the proceeding, to promote a settlement of the proceeding, and to identify the question of fact and law to be decided by the tribunal. If you think that a case is possibly capable of being resolved or settled, it's always a good idea to take advantage of the compulsory conference procedure, because it's conducted in private, and generally evidence of anything said or done in the course of the compulsory conference isn't admissible in the subsequent hearing. And it is desirable that you settle these cases. It's undesirable from my mortgage perspective, but it's desirable from the health practitioner's perspective, because in the interests of transparency, subject to its reviewing the matter, VCAT has shown a preparedness to act on and accept any agreement the parties may reach in relation to each of the factual finding, the characterisation of the conduct, that is, whether it's unprofessional conduct or professional misconduct or whatever, and even the ultimate determination. If you can reach agreement as to the ultimate determination between the two of you, you can go before the tribunal, and the tribunal will, provided it's reasonable, will generally accept that. And I've got a couple of cases there, sketcher of which I was involved in which the parties have, in advance of the hearing, discussed the case and reached some consensus about the case, and jointly submitted a written document being an agreed position on factual findings, characterisation and/or ultimate determination. And so, as I say, generally speaking, the tribunal will endorse any agreement reached between the parties, provided the sanction proposed is within the permissible range. And there's authority for the proposition that I've spelt out here, that where a regulatory body and respondent have reached a negotiated settlement and the penalty proposed is, broadly speaking, within the permissible range, having regards to all the circumstances, the court, or in this case the tribunal, should not depart from the agreed sanction. Okay, now witness statements. When you're preparing the case, you have to lend consideration as to whether you generate a statement from the respondent health practitioner or by the respondent health practitioner. In fact, he or she does not have to file a statement or serve a statement with the tribunal in advance of the hearing. Now, you might think it's odd that I should say that, in light of the fact that the tribunal will generally order that any statements be, all statements to be relied upon must be generated in advance of the hearing, and the practice note wording suggests as much. However, in Towie's case, the Court of Appeal held in effect that in proceedings where a person is exposed to a civil penalty, it's not appropriate for a court or tribunal to require that person to provide a positive assertion or denial of facts before the case advanced by the applicant has been completed. I suppose it's only natural justice, isn't it, that until the practitioner actually hears the allegations in court, or the tribunal in this case, the practitioner shouldn't be required to respond to those allegations prior to that stage. And so that's the tenor of Towie's case. However, some members don't like it. I know when I was looking after Dr Young, Senior Member Davis, I said, oh yes, but the doctor didn't have to provide a statement, sir, because of Towie's case. He said, oh yes, I know that, Mr Kesh, but still I would have liked it. And so he wasn't happy about it. And so you might think that there's no harm to be gained by generating a statement by your client health practitioner and providing it in advance of the hearing. But it's a matter for you. The statements of expert witnesses. You don't have to have your expert witness generate a statement in the form of a lay witness. You know how you'll write up to the expert and the expert will send you a report. You can just serve that report. But you just got to be mindful that there are a couple of things that should be in that report, and they're spelt out in the second practice note. So just have a look at the second practice note to make sure that the reports contain those sorts of things which should be in there. Statements of lay witnesses as to facts in dispute, they need to be served on the applicant by the time stipulated in the orders. But statements as to lay witnesses as to character, there's a more lenient attitude generally adopted, and those are regularly served late with leave of the tribunal. That may change with the new practice note, but generally speaking, there's no great objection if they're served late, particularly if you've got the consent of the other side. Insofar as the tribunal book is concerned, I'd just like to suggest to you that you really should, if there's something in the materials that you take exception to and you don't want the tribunal members reading in advance of the hearing, raise it with your other side and say, look, we don't want them reading this. It's contained on page 43, paragraph 5. Can you please excise that? If you want it in the materials at the hearing, let's ventilate it at the time. But in advance, I don't want them reading that. Now, your opponent will generally be reasonable and will say, all right, I'll extract that. We won't put it in the tribunal book in advance, but we do want to rely on that, so we might have to ventilate it at the outset of the hearing. The hearing itself, of interest at page 7 under the topic suppression orders, it's always the case, isn't it, that your client health practitioner is going to be so sensitive to publicity that your health practitioner will say to you, look, is there any way we can suppress my name? Unfortunately, although the Act allows the tribunal to suppress the practitioner's name if it's in the interests of justice, the standard practice is to refuse any such application, and that really is the case. You are seldom going to be successful in making an application for suppressing the practitioner's name. And if you want some authority for that proposition, it's provided there in the case of the Psychology Board of Australia and D. Okay, so the finding stage. So what we're talking about is that stage of the proceedings where facts and characterisation of the conduct are concerned. Onus of proof, of course, is always on the professional board, but let's look at the standard of proof. Brigginshaw's on the way out. Section 140 of the Evidence Act appears to be on the way in. However, in practical terms, I don't consider there to be much difference at all. And in recent times, in a case I did of Jantz, Her Honour Judge Jenkins effectively suggested as much, and that's referred to. Brigginshaw, of course, is the test formulated, the old test formulated by Mr Justice Dixon, where on balance the tribunal has to be satisfied to the reasonable satisfaction of the tribunal, taking into account the gravity of the circumstances. Now, if you look at the wording of section 140, it's more or less the same, isn't it? we were jumping up and down, or my solicitor was, in Jance, that there's been a departure from Briginshaw. How dare she rely on Section 140 of the Evidence Act? But really, there's not much difference. It comes about because Judge Hampel, in Cobor's case, first decided to effectively do away with Briginshaw and these sorts of hearings and rely instead on Section 140. But she said, quote, "It's important to bear in mind that the standard remains satisfaction on the balance of probabilities. What Section 140 and the judicial considerations of it say, in effect, is having regard to the nature of the allegations, the strength of the evidence necessary to establish a fact or facts on the balance of probabilities may vary." And that's, in effect, she's saying, depending upon the seriousness of the allegations. So I don't perceive that there's really much change or that we ought to be jumping up and down about it. If the allegations relate to what, in effect, amounts to criminal conduct, I looked after Dr. White, who had the patient in the consulting room, and there was a young child, about 2, in a nappy, belting at the door, sending the doctor insane during the consultation, and so she opened the door and smacked the child on the bottom, and technically an assault. And so if an allegation could amount technically to criminal conduct, arguably even greater caution needs to be taken by the tribunal, and Anderson and Blaschke is referred to, where Mr Justice Gobbo said, these being civil proceedings, an inquest, the assault allegation is required to be proved on the lesser standard of the balance of probabilities, despite the criminal nature of the allegation. But because of the gravity of the allegation, proof of the criminal act must be clear, cogent and exact, and when considering such proof, weight must be given to the presumption of innocence. Now, insofar as the application of the rules of evidence are concerned, strictly speaking, the Act authorises the tribunal to have a fairly laissez-faire approach. But in practical terms, there is practical adherence to notions of fairness, of course, as of course there should be, like Brown and Dunn. But there's practical adherence to the rule in Jones and Dunkell as well. That is the rule that in the absence of a reasonable explanation, the trier of fact may draw an adverse inference from the fact that a witness who might be expected to be favourable to a party is not called by that party. And Mark O'Sullivan and I had the awkward experience in Young's case, where I argued that the prospects of the respondent medical practitioner suffering a relapse of a psychiatric condition were remote. We called one psychiatrist who gave evidence to that effect. However, we didn't call another psychiatrist, a second psychiatrist who'd been treating the respondent, medical practitioner. But we didn't, because it was a perfectly valid reason, or at least we thought so, and the practitioner articulated as much in the witness box when the practitioner said, look, that other psychiatrist, he only became involved in my treatment, as it were, because the psychologist that I was seeing wasn't able to prescribe medication, and so all the second psychiatrist did was prescribe for me. The tribunal held that despite the explanation given, the tribunal could infer from the non-calling of that second psychiatrist that he wouldn't have assisted the respondent's case when it came to assessing whether the respondent might suffer a relapse of his psychiatric condition and thereby pose a risk to any potential future patients. Okay, so the determination stage, this is often erroneously referred to as the penalty stage. It's not a penalty. These aren't punitive proceedings at all. But I suppose, by analogy to criminal proceedings, these are the penalty. This is the penalty stage, but they're not strictly speaking the penalty. It's not strictly speaking the penalty stage. But the practitioner should generally always give evidence during this stage. In a criminal proceeding, you wouldn't call your client because it would be too dangerous. The sorts of questions that would be asked of your client could see you in hot water. But in these sorts of proceedings, you really must call your client. You must call your client for this particular reason. They really need to see the practitioner to make a judgment about the practitioner's improvement or insight or contrition or whatever. In Schultz, I didn't call the Chinese medicine practitioner because the very valid reason, and I couldn't spell it out then and I can't spell it out now, but the tribunal expressed concern that it had been deprived of the opportunity to see him subjected to cross-examination, to ask him questions on oath and to really gauge his level of insight and contrition. I can say, though, with confidence that had he been called and had he been subjected to those sorts of things, the outcome would have been a hell of a lot worse for him. Character witnesses may, of course, be called at this stage. Just be conscious that the first question a character witness might be asked by competent counsel is, tell us about what he told you. What did he tell you about this? So just always make sure before you call a character witness that the character witness, if the character witness is going to be asked a question like, what version of events did the practitioner give you, that version of events is consistent with your clients. Otherwise, you'll be in hot water. The law in relation to determinations. I've spelt it out. What you've got there is a summary of all of the main propositions in relation to determinations. The sole prerogative of the tribunal for the purpose of the imposition of determinations in this disciplinary matters is to protect the public, and C, determination should in no sense be punitive. Now, what you should be doing, E is the likelihood of recidivism, or put another way, an assessment of the ongoing risk posed by the practitioner should be central to the imposition of a determination. And you can see G, the degree to which the practitioner has acquired insight into his conduct is particularly significant in that it goes to the continuing risk posed by the practitioner. May I suggest that in your preparation for the determination phase, you should really focus your client, prepare your client to be able to demonstrate those things in the witness box, that your client isn't going to relapse and engage in this sort of conduct again, that your client really does have insight into, and it's articulated there under GI, insight into an appreciation of the nature of the conduct, that it's wrong, and that he or she appreciates why he engaged in that conduct and empathises with the victim, or understands why he's done what he's done, and can illustrate a willingness to take measures to identify risk factors and to do that which is necessary to avoid further transgressions. In relation to some of the specific determinations that may be imposed, I just want to address this, what I've got here in relation to suspensions. The tribunal won't impose a suspension if it has a doubt that at the expiration of the period of suspension, the practitioner will be fit to resume practice. So you've got to convince the tribunal that, look, if you take us off the road, as it were, for 6 months, we're perfectly okay to resume practice. Otherwise, you won't get a suspension. You get something worse. B is interesting because of an experience I had recently in the case of Munzel. The tribunal will be loath to impose a period of suspension for a period any less than the duration of a sanction imposed in relation to the same conduct by the criminal courts. Mr. Munzel, remember I told you he'd indecently performed an indecent act with his daughter, was charged with that and received a 2-year good behaviour bond. I think the hearing at VCAT was about 14 months after the imposition of that 2-year bond. And for that reason, the tribunal imposed a suspension, taking it up to 2 years. So in effect, he was suspended for 2 years. And although it didn't say as much, I suspect it's because the bond was for 2 years. Interestingly, the board in that case had sought a suspension for 8 years because the Magistrates Court had imposed a condition that he be on the sex offender registration list for 8 years. But the tribunal felt that well, didn't express it in these terms, but felt that that wasn't necessarily a criminal sanction, and so didn't effectively impose a suspension on his general registration for 8 years, but rather just for 2 years. There's a little bit about cancellation there, but noting the time, I'd just like to move on to a couple of things on the last page, and in particular costs. Now, VCAT, of course, is a no-cost jurisdiction, isn't it? Well, that's wrong. We generally approach it thinking along those lines, and well, we might, because generally speaking, almost always costs never are imposed, an order for costs never made. However, Section 109 provides that VCAT may indeed order a party to pay the other party's costs, and David Curtin and I are meeting a submission presently in writing that the practitioner ought to pay costs in the case of skiing. I can't say too much about it at the moment. It hasn't been published. The findings have been made but haven't been published. But VCAT made findings against the practitioner in effect that in defending the allegations, he conspired with a witness. They put their heads together, in other words, to mislead VCAT. So VCAT's now entertaining argument later this month on the question of whether or not the practitioner in that case ought to be ordered to pay costs. So just be conscious. And you might tell your practitioner this, that if the practitioner's silly about the way he or she goes about defending the allegations, he or she could face an order for costs. And just finally, insofar as handing down a decision is concerned, when the decision is handed down, just be conscious that it may be weeks or months after the event. Your client, the practitioner, doesn't have to be there, but the orders may be, if not cancellation, maybe suspension of the practice, and they generally operate immediately. And if that is the order of the tribunal, don't be afraid to ask for a stay of the decision just for a short period, so that your practitioner can get his or her affairs in order for a couple of weeks maybe, and the tribunal doesn't show any reluctance to stay its decisions for a short period of time. So I hope that's been of assistance to you. Thank you.
Is there anyone who would like to ask quickly a few questions of our presenters? Yes, sorry, Mr. Devine.
Sean, could you say something quickly about the right of a practitioner who's been suspended under the immediate action powers, pending investigation being completed, the right of a practitioner to take the matter to initiate proceedings in VCAT?
To initiate proceedings in VCAT?
Yes. In other words, to appeal against or to challenge the suspension in VCAT.
Look, I don't have the Act in front of me at the moment, but it's seldom done. I don't know whether it's to the Supreme Court or VCAT, in fact. So I'm afraid I can't assist you at the moment in relation to that. Presumably, if it's to VCAT, you're running the same argument. You simply it's simply an appeal. I recognise that there's a mechanism there, but it's simply an appeal that you would run the same argument that you're not a risk to the community. You would mount the same arguments you do at the show cause hearing. The practitioner isn't a serious threat, a serious risk to the community.
And Sean, does it make sense to try and offer up some self-imposed conditions?
Yeah, it does, David. But can I just say that it seldom happens that you need to be concerned about appealing a decision suspending pending the hearing. I find that the Medical Practitioners Board of Australia is pretty lenient, I must say. But David, I agree with you. If you can go to the medical board at the show cause hearing with a fallback position, look, board, I'm prepared to not prescribe Schedule 8s, or I'm prepared to only to look after male patients pending the expiration of the investigation. The tribunal will invariably accede to your request to continue to practice with those conditions. I've gone there and made suggestions to them that, look, we're prepared to do these things pending the outcome, and they've said, look, you don't have to do that. We don't require you to do that. But it's always nice to go there with a suggestion that you're prepared to do that in advance. So I think we might talk about that later, Ross.
Okay, well, we spent a lot of time thanking a lot of people, and I do thank our presenters, but more importantly, I thank you all for coming. It's a pleasure to have you here. I hope it's been of assistance to you, and on behalf of Michael and his staff, thank you very much for joining us, and we've enjoyed your company, and have a good day.